Okay, so some introductions to who's going to be speaking today. Well, we've got Louise Fryer, who has 24 years of experience working in global mobility. She's worked with a wide range of international companies of varying sizes, from corporates with a dedicated global mobility team to companies who do not have a specific team dealing with international travel. Louise is also a consultant editor for Tolly's Global Mobility and Employment Taxes. Louise is going to be joined by Rebecca Hone, who leads our UK immigration law practice, specialising primarily in corporate immigration. And Rebecca guides businesses setting up, expanding in the UK, in applying for a sponsorship licence to employ migrant workers, and once granted, advises her clients on utilising their licences to hire sponsored workers and retain them as staff, in addition to proactively managing their licenses to remain compliant with various sponsorship duties. And finally, we're joined by Donal Moon, who is an employment law advisor in our HR and employment law consultancy. He works as a team with HR consultants to keep clients on the legal straight and narrow, advising on all aspects of employment law, including unfair dismissal, breach of contract, wage claims, TUPE, and many, many more. His focus is on giving clients sound yet commercial employment law advice to help them reduce their risk and achieve their goals. A little bit of housekeeping whilst we await for the last remaining people to join. This is being recorded, so please do share it with your peers or anybody who could not make it this afternoon. And please do ask questions as we go along. This is a webinar for you. You're going to get the most out of it by raising questions, because that's when the discussion gets going. I will do my best to bring those questions into the discussion in the relevant places as we're going. But any questions we don't get to, there should be time at the end to pick those up. So I'm doing a bit of light sharing, and panelists are going to do all the important speaking. So we're going to kick off with Louise, who is to cover the recent budget implications on employment taxes and global mobility.
Okay, thank you very much, John, and good afternoon to everyone. I'm sure that the majority, if not all of you, are now very familiar with the changes Rachel Reeves delivered in her first budget. But I'm going to start with a very brief look at the main things affecting employers and employees generally in the UK, and then move to focus on a couple of the most significant changes that will affect companies with globally mobile employees, and look at what can be done to reduce the impact. Okay, can we move the slide, please, John? Okay, so we have an increase in the minimum wage from April 25. National living wage increases to £12.21 per hour. The national minimum wage, which is slightly different, for 18 to 20-year-olds increases to £10 an hour, and the under 18s and apprentices to £7.55 an hour. National insurance increases are something that's attracted a lot of attention, and we're going to go into more detail in that later. So next slide, please, John. Okay. Mandatory payrolling of benefits in kind. So these are things that employees receive, such as medical benefit, company cars, and they're currently reported annually via a Form P11D, and an individual's personal allowance is changed to account for the tax due on the benefit. The government confirmed in the budget that there will be a mandatory requirement for employers to collect tax, including Class 1A NIC, that is due on the benefits in kind through payroll. So no more P11Ds, everything has to go through payroll, and this will be mandatory from April 2026. It is possible to payroll benefits on a voluntary basis by registering with HMRC, and we've seen quite a few employers do this so that they get through any teething problems before it becomes mandatory. Umbrella company non-compliance. This is an interesting one and isn't dissimilar to the IR35 changes we had a couple of years ago. An umbrella company is an employment intermediary that employs workers on behalf of recruitment agencies and their end clients. Contractors often use them because they offer convenience and administrative benefits and take some of the pain of the paperwork away. Currently, PAYE is operated by umbrella companies for the workers that they employ. But going forward from April 2026, the responsibility will pass to either the agency or the employer to ensure the correct income tax and national insurance is deducted and paid. They will also be liable for any shortfall, and that's the case whether they operate the payroll themselves or use the umbrella company to run the payroll for them. So essentially, the company or the agency can make the umbrella company run the payroll, but if it's wrong, it's not the umbrella company that suffers. Where there is no agency involved, the responsibility passes to the end client. So in other words, the employer. As I said, proposed implementation date is April 2026. So maybe some thought needs to be given to that in the coming 12 months. The new legislation will need extra careful consideration where there is an international element, whether it's the umbrella company, the agency, or the end user. We had quite a few complications with IR35, and I imagine they'll be the same under the umbrella company legislation, but we'll have more to follow once HMRC have drafted and published the new legislation, more to follow. And finally, we have company cars. Tax rates for 25-26 were updated, and legislation is to be drafted to address a loophole in car ownership arrangements, which results in no payment of company car tax. So that's closing a loophole. So next slide, please, John. Let's look now at the changes in UK national insurance and how this may affect companies that have an international presence with a presence in the UK, or who want to have a presence in the UK. So from the 5th of April 2025, so at least we don't have to deal with a mid-year change in rate, and I'm sure payroll will be very relieved about that, having experienced that quite recently. The employer's contribution rate has increased from 13.8% to 15%. And employers must start to pay employer NIC much earlier when an employee earns more than £5,000 a year as opposed to £9,100. So that's quite a shift. The employment allowance, which is available to employers to help offset their national insurance bill and is a one-off credit per year, will increase from 5,000 to 10,500. But this is going to have very little impact for a large employer across a large employee population in offsetting the additional cost. Just to put it into context, the employer NIC charge for an employee earning £35,000 will increase by £925 per annum. There's no upper limit, and so the increased 10,500 allowance will very quickly be swallowed up. Whilst employers will be entitled to tax relief on this additional employment cost at 25% for companies, this undoubtedly represents a large increase in employment costs. And this is for every company that has employees in the UK. But what about the impact on employers with UK touching cross-border workers? We've seen the search for key talent become increasingly international, with companies keen to attract and retain the best people. Global mobility now has a seat at the table in many organisations and is becoming integral to strategic decisions. Higher levels of employer NIC will increase the costs for companies with UK-based employees, and as the cost of employing people in the UK increases, it follows that the UK will potentially become less attractive to companies seeking to expand internationally. For international assignments, the additional NIC cost will not be the only consideration, as there will be a knock-on effect to the tax gross ups where employees are tax equalised. Tax equalisation costs companies a lot of money already. This is just going to make it worse. So let's take a look at some of the ways in which employers with a globally mobile workforce could manage their people in a different way to try and keep costs down. Although it should be noted that other countries may still have higher contribution rates from the UK, and it should always be looked at in detail in conjunction with tax charges and the rest of it that goes with an international assignment. We'll start with UK inbound employees. The UK has social security agreements with many countries, and where one is present between the UK and the home country of the employer may consider changing the structure of their assignments so that a certificate of coverage or a certificate A1 can be obtained, and the individual, and importantly the employer, continues to pay into the home country scheme. That has many advantages, and some of which we'll go through. But advice should be taken for individuals whose home country is in the EU or the EEA, because eligibility criteria has changed following Brexit. And there are 3 different sets of legislation depending on how long that person's been in country. Where there are no social security agreements, and we do have countries that we don't have agreements with, firms, we imagine, will be looking to try and satisfy the conditions needed to claim a NIC exemption for the first 52 weeks of an assignment. So where there is no agreement, an employee comes to the UK for the first 52 weeks, there is no UK national insurance payable. However, contributions may still be due in the country of origin for that 52-week period. And again, it needs to be checked on a country by country basis. So that's what can be done for employees that are moving to the UK. For UK outbound employees, there are ways to remove that mandatory NIC obligation. So the employer might consider moving the employee to a local contract in the host country, or extending the length of the assignment to break UK residence for social security purposes. Both of those are ways to make somebody stop paying UK NIC. In both these scenarios, social security payments become due in the host location, and UK NIC is no longer payable. If the rate in the host location is lower, the employer will save money. However, the individual's long-term UK position should be considered, as gaps in their national insurance contributions record will impact their entitlement to a full UK state pension. One way of mitigating this is for the individual to make payments under the UK voluntary scheme. The cost is significantly lower than Class 1, and the individual's pension record is kept whole, although access to certain state benefits is not available during the period of voluntary contributions. But if they're working abroad, that's not really going to affect them anyway. The contributions are made directly by the employee, and there is no employer element. So that's possibility there. It's just something to mention as an aside, and this has nothing to do with the budget, but there has been an announcement by HMRC to say that there is less than 6 months left to fill in any national insurance gaps in a person's record that occurred before 2006. So it might be worth checking on HMRC's website in terms of if you have missing years. Things for an employer to think about. There's still a short period before the increased rate kicks in April. So an employer might want to think about accelerating certain remuneration, such as a bonus, to be paid before the 6th of April 2025 to benefit from the lower employer NIC rate. This can be quite straightforward, but on the other hand, if it's performance bonuses and there are certain conditions attached, then it might require a bit more legal help. It's also a good time to revisit pension salary sacrifice as an option to mitigate the NIC increase. The rumoured introduction of employer NIC's charge on pension contributions did not materialise in the budget, although we are aware that the government plans to introduce some changes to pensions, but salary sacrifice is a great way of saving money and the employee benefits. An employer may find it helpful to set up what's called an Appendix 7A or 7B modified national insurance scheme with HMRC if they have tax equalised assignees. In much the same way a modified payroll does, a modified NIC scheme enables employers to undertake post-year-end reconciliations. This can be invaluable because whilst NIC was correctly captured through payroll, the income may be eligible for tax relief that needs to be claimed via the UK tax return and therefore isn't actually due. If you have a modified NIC scheme, then this will facilitate a reclaim of the overpayment. Overseas workday relief is a good example of this kind of thing. Salary goes through payroll as normal, but the employee, when he fills in his tax return, can claim tax relief for certain days spent overseas. When the money went through, or the income went through payroll, NIC would have been charged in full. But because that tax relief is being claimed, that NIC has been overpaid. So a modified NIC scheme would enable that money to be clawed back. At a time when many European countries are offering incentives to attract employees under regimes such as the Golden Visa or the Digital Nomad Visa, the increased employer cost approach in the UK seems counterintuitive. Rebecca will look at changes to UK immigration law and the potential effects later in this webinar, but it does seem slightly odd. Okay, can we have the next slide, please, John? Non-dom changes were the big headline, and it's been rattling around for a while. First, the Conservatives decided to do something about it. Then the Labour came in and changed some of the rules. And finally, in this budget, they have now come up with what's going to change. Essentially, the tax concept of UK domicile will be abolished from the 6th of April 2025, which means that currently a non-domicile can elect to be taxed on either the remittance basis, so on money they bring to the UK, or the arising basis, which is their worldwide income. When a person elects for the remittance basis, they're taxed on their UK employment income, any UK source income, but any monies that they earn abroad, if they stay abroad, wouldn't be taxable. So that disappears. And without that remittance basis, everyone is taxed on their worldwide income and gains unless they meet the requirements for the new foreign income and gains regime in place from the 6th of April. This regime is based on residence and will provide 100% relief on foreign income and gains for new arrivals to the UK in their first 4 years of tax residence, provided they have not been UK tax resident in any of the 10 consecutive years prior to their arrival. Now, 10 years is a long time. We'll look at the effect that that 10-year period has on being able to claim overseas workday relief a bit later on. Under the new FIG regime, it's a great name, any previous foreign income and gains that arose whilst an individual was taxed under the remittance basis will continue to be taxed under the current rules when and if people remit it to the UK. So you can't just bring all your money to the UK that you've earned in the last 5 years and not worry about any potential UK tax charge. The rules will remain for those monies, so they will need to be segregated and identified, essentially. However, there will be a bit of a tax break for individuals who have previously claimed the remittance basis, and that is a 3-year temporary repatriation facility, which allows for the foreign income and gains that arose on or before the 5th of April 2025. So the monies we were talking about just now can be designated and brought to the UK at a reduced rate of tax. So we're looking at 12% for the first 2 years and 15% in year 3. Now, if that repatriation facility isn't used or the figure election is not made, any money that comes to the UK will be taxed at a person's marginal rate, and that could be as much as 45%. So it's definitely something that needs to be considered. Next slide, please, John. And now we're going to look at overseas workday relief, because this is quite a big thing for people who come to work in the UK and can provide them with a great deal of UK tax relief. In its current form, overseas workday relief is an income tax relief available to UK resident, non-UK domiciled employees for up to 3 years on earnings related to days spent working abroad as part of their UK employment. It's a claim that's made through the tax return and has to be substantiated by a calendar, by keeping a calendar of where you are, when you are, and what you're doing. Being able to claim this relief can generate significant tax savings for people who are working temporarily in the UK. However, the current regime involves some complex bank account structuring, with income related to the days spent working outside the UK never being brought to the UK. If that money is brought to the UK, there is an awful lot of analysis that has to go into how taxable it is in the UK. So I don't think people will be upset to see the back of that. Going forward, in order to claim the relief, an individual must qualify under the foreign income and gains regime, as we said earlier. And we also mentioned the criteria for a 10-year period of consecutive non-UK residence. This also applies if you want to claim overseas workday relief. The period at the moment is 3 years, so a significant increase there for people that can claim it. Expats often return to the UK for a second assignment within a 10-year period, and being able to claim that relief is a big cost saving, whether it's to the employee on an ordinary assignment or whether it's to an employer on a tax equalised assignment. This is a new barrier now that exists for talent being free to go where they need to be. As I said, very often people will come to the UK 2 or 3 times. They are high profile, they're high earners, they're known for moving things on and getting things done. Now, that person might not be able to revisit, or if they do, it's going to cost them a lot of money. Other key points for the overseas workday relief regime are bank account structuring will no longer be necessary, as having the income paid and keeping it offshore is not key to claiming the relief. You can have all your salary paid into a UK bank account and still claim it. Overseas workday relief has been extended to a 4-year period, so there's that extra year, and that is because it needs to align with the new foreign income and gains regime. Presently, there's no limit on how much a person can claim, but going forward, it will be limited to the lower of £300,000 or 30% of the employee's net employment income. Any trailing income paid after the 5th of April 2025, but that relates to a period prior to 5th of April 2025, will continue to be taxed on the remittance basis. So if an assignee comes to the UK, stays, has a bonus that's paid to him once he's returned back home, that's still subject to UK tax, and it will be taxed on the remittance basis. Earnings that have previously not been taxed in the UK are eligible for temporary repatriation facility, and for individuals resident in the UK who are currently partway through their overseas workday relief claiming period, HMRC have drafted transitional rules that will apply. There's a lot to think about for people that are currently in the UK or will be moving to the UK before April 2025. There their tax position isn't straightforward anyway, but it's going to be even less straightforward now because of what they'll need to think about and what they'll need to be advised to do. There were a couple of other announcements that will affect the cost of sending someone to work in the UK. VAT on school fees. Companies often pay for assignees' children to go to a private school, so VAT poses an additional cost, even higher if the individual is tax equalised. Air passenger duty will increase per flight, different amounts depending on the length of the flight. So flights to and from the UK will be more expensive. But if you have a private jet, the already higher levy will increase by 50% from April 2026. So perhaps it's time to sell that aeroplane. One positive move, and what we see as a significant step forward, is the removal of the need for employers to make a special application to HMRC to operate PAYE on only a proportion of employment income, known as a Section 690, so long as certain criteria were fulfilled. These arrangements are often utilised by companies where there is payroll withholding requirement in both the UK and a second country due to the nature of their work and the assignment. It's no secret that the length of time it was taking HMRC to process these applications was far too long, meaning that individuals were effectively overpaying the UK tax due and potentially experiencing cash flow problems, sometimes for over a year because of the length of time processing was taking. The same criteria still need to be fulfilled. It's not just something you can operate on a whim, but I think employers and employees alike will heave a sigh of relief that they are able to apportion PAYE without that long waiting period to be approved by HMRC. Next slide, please, John. So I just thought I would finish with the potential conflict. The message from Rachel Reeves in the UK Autumn Statement budget on Wednesday was about rebuilding the UK economy, driving economic growth by investment and getting people back to work. However, many of the changes announced and the ones we've gone through in this webinar are increasing the cost of employing individuals and may deter international investment in the UK by looking to expand into new territory. So interesting times ahead, and we will have to see how it affects investment in the UK. I'm now going to hand you over to my colleague Rebecca, who will talk to you about changes afoot in the world of immigration.
Well,
Rebecca.
hold on for 1 second there, Louise, just to interject. There's a few questions that have come in. So
Okay.
thank you very much for that detailed assessment. But one of the questions that's been raised is, I believe it's in the context of an employee that's already UK resident and presumably planning to stay in the UK for future years, and they've asked, can that individual now bring money to the UK that relates to prior years when the remittance basis was claimed without worrying about it being taxed? For example, can they bring in money related to previous overseas workday relief claims to the UK under these new FIG regime rules?
There's nothing stopping them bringing the money to the UK, but they will need to remember that that money was earned whilst they were claiming the remittance basis, and the money they bring to the UK will continue to be taxed under the remittance basis. What they should be thinking about doing is taking advantage of the temporary regime where the tax rates are lower, and they've got the first 2 years at 15% and then the third year at 12%. So if you're going to bring you money to the UK, it's still worth putting some planning around it and taking advice. You're free to bring it, but there will be tax consequences if it's not carefully thought through.
Okay. So that nicely deals with the tax side of things, and sometimes businesses might jump to considering, or what are the tax implications of hiring people in the UK or seconding people to the UK. But it's often important to, as a first step, check that all employees have a right to work in the UK, which I think nicely moves on to Rebecca's section where she's going to cover off immigration.
Hi, everyone. Thank you for joining today. Although the recent budget did not shed much light on Labour's plans for immigration policy, their agenda is clear: to reduce net migration to the UK and make the changes necessary to prevent abuse of the immigration system as it stands. Today, we will look at firstly, the 5-point plan brought in by the Conservatives to reduce net migration. We'll look at Labour's plans to strengthen and better utilise the MAC, which is the Migration Advisory Committee, to more accurately inform immigration policy. We'll take a look at the drastic increase in sponsor licence and right to work compliance for UK employers. And then lastly, we'll touch on the first stage of reforming the UK's online sponsorship system, which has begun with a trialing of its new sponsorship service for government authorized exchange sponsors. Next slide, please. So with this 5-point plan to reduce net migration, the first part of this plan is reforms to the skilled worker health and care visa, which is for doctors, nurses, health professionals, and care workers. The inclusion of carers was a pandemic measure, and it's now likely to remain with a continued, due to the continued underinvestment in the sector and the aging population in the UK. The Care Worker Occupation Code for sponsoring, it remains on what's called the Immigration Salary List, which is formerly known as the Shortage Occupation List, which provides a kind of discounted salary for certain occupations. But it's something to watch because there's high levels of abuse and worker exploitation, so this may change. Changes brought in by the Conservatives remain, in the sense that care workers cannot bring their dependents, and sponsoring care homes must be registered with the Care Quality Commission. Secondly, this year, there has been an increase in the general salary threshold for skilled workers, which came in April. This increased drastically from 26,200 per year to now 38,700 per year. And skilled workers, they must be paid either this minimum amount or the going rate for their occupation code. This increase means that the minimum salary for skilled workers is now higher than the gross median earnings for UK full-time employees, which as of April is around 37K. And this results in sponsorship only being available for those in the upper end of medium-skilled occupations. And then lastly, there is exemptions to this general salary threshold for certain categories. So there's the immigration salary list, the health and care workers, and then for those under the age of 26, those on specific categories of visas, such as student and graduate, and those with a PhD in a STEM subject. Thirdly, as I've said, the shortage occupation list has been replaced by the immigration salary list. And on this immigration salary list, there is that lower general salary threshold of 30,960. But still, workers must be paid the higher of this or the going rate for their occupation code, which varies depending on what they do. This lower going rate applies for health and care workers, and also for skilled workers who had sponsorship prior to the changes coming in April, and they're extending their sponsorship. So also, in terms of reducing net migration, there's been changes to the family visa. So this includes partners, spouses, unmarried partners, children. It used to be that the sponsoring family member had to earn at least 18,600 per year gross. But now this has gone up to 29K. Originally, it was set to increase to the salary threshold for skilled workers, which is 38,700, but this increase has been paused while the Migration Advisory Committee has been commissioned to conduct a review to see whether it's balancing the respect for family life against UK economic well-being. And then lastly, there is this graduate route. So the graduate route was introduced in 2021. It's a non-sponsored visa, and it gives student visa holders the ability to extend their stay for a further 2 to 3 years with a full right to work. Dependents are permitted on this route if they were dependents on the student who they came with. So it gives an extension of their stay, and there were concerns about whether there's abuse of this route as a way to stay longer in the UK and work and look for sponsorship opportunities. Because of this, the Migration Advisory Committee was commissioned in March to conduct a review of the route, and there were concerns that the route would be scrapped. But following the review, it's been found that there hasn't been widespread abuse of the graduate route. It's here to stay. It doesn't undermine the integrity and the quality of the UK's higher education system. And the attraction of international students is actually economically beneficial to make up for losses with domestic students. It's been recommended that the graduate route should stay in its current form, but that being said, there are increasing measures in place to regulate the recruitment of international students, such as reviewing the evidence used to meet financial requirements and English language assessments. So overall, this is the 5-point plan in place to reduce net migration in the UK. Next slide, please. So since Labour has come in, the Home Secretary has commissioned the Migration Advisory Committee to strengthen the committee to better inform UK immigration policy. As part of this, Home Office staff have been sent to the MAC to ensure that there's strategic forecasting of future migration trends and to ensure that there is the provision of independent evidence-based recommendations. As part of this commissioning, the Home Secretary has asked the MAC to conduct a comprehensive review to understand why UK employers rely on international recruitment in certain sectors, those being IT, telecoms, and engineering. IT, telecoms, and engineering sectors are amongst the top 10 most dependent on international recruitment in the UK. And even though these roles have been removed from the immigration salary list where employers can benefit from a discounted salary, it has not decreased the level of skilled worker sponsorship, further highlighting the need for specialist skills in the UK and a shortage of homegrown talent. As part of Labour's plans, there will be a greater cross-functional collaboration between government bodies to create a wider workforce strategy to address labour shortages in these sectors. So they'll be joining up immigration, skills, and labour market policies. These include, for example, the newly formed Skills England, the Industrial Strategy Council, and the Department for Work and Pensions, with the greater goal of attaining a more evidence-based approach to filling existing gaps in the UK labour market. Next slide, please. Apologies, can I just go back? I didn't finish. So as part of their review, the Migration Advisory Committee will consider which roles in these sectors are in shortage and why. So looking at training, pay, and conditions. They'll look at how employers have attempted to address these shortages outside of international recruitment. They'll look at potential immigration system changes to encourage these sectors to recruit from the resident workforce. Employers and various stakeholders will be engaged as part of the review. It must be completed by May 2025, and following this, the government may use these findings to adjust the eligibility criteria for sponsoring workers in IT, telecoms, and engineering roles. As of yet, there's been no indication from Labour of a return of the resident labour market test, which was scrapped in January 2021 after Brexit. However, if existing immigration regulations are amplified to document efforts to hire a UK citizen or a settled worker over a non-settled worker, the process of recruiting a migrant worker could become much longer and elaborate. We're monitoring this space and we'll keep you updated. Next slide, please. So there has definitely been an increase in sponsor license compliance in the last 6 to 9 months. Whether this has to do with Labour or whether this is a follow-on from the Conservative plan, it is still happening. For example, in the first quarter of this year, approximately 500 sponsor licenses were either suspended or revoked. In the second quarter of this year, this has gone up to 1,000 sponsor licenses that have been suspended or revoked. This is quite a drastic increase, and it would align with Labour's plans to reduce net migration. The Home Office has increased the frequency and the thoroughness of their on-site inspections and audits. These inspections, they can be announced, they can be unannounced, they could be part of the license application process, or they could be post-license. And during these visits, the Home Office can also request to review right-to-work check documentation, such as visas, copies of employment contracts, etc. They can interview sponsored workers, they can interview key personnel on the license. With sponsor compliance action, it includes things such as license downgrades, which results in being unable to sponsor new workers, suspensions or flat out revocations, sometimes with bans on reapplying for a certain amount of time. This, of course, ultimately is detrimental for the business. If you lose those sponsored workers, their visas are canceled, they lose the right to work. In terms of right to work compliance, there's what is called illegal working civil penalties. And in February of this year, the fines for illegal working civil penalties have gone up dramatically. So for a first offense, it's gone up from 15K per sponsored worker to 45K per sponsored worker. Not sponsored worker, apologies, for any illegal worker found. And then for repeat violations, this has gone up from 20 to 60K per worker. And additionally, companies are named and shamed on a public register. So overall, compliance is going up. Ensuring that you are up to date and compliant with your sponsor duties is more important than ever. Next slide, please. Recently, last month, we've received news from the Home Office that they will be rolling out their new sponsorship service, which will replace the current one. It's called Sponsor UK. The current sponsorship management system is very old, it's outdated, it's not user-friendly, and so it's music to sponsors' ears for a new system to come into place. In terms of how it's being introduced gradually in what they're calling a series of private beta phases. The first phase is only for government authorized exchange sponsors who sponsor temporary workers doing work experience or training on approved GAE schemes. Initially, these PB1 sponsors will be able to use Sponsor UK to sponsor new GAE workers, extend the sponsorship of existing workers, and report changes in the circumstances of their workers. But for the remaining sponsorship functions, such as reporting changes to the sponsoring organization, they must continue to use the current SMS. Early information indicates that Sponsor UK will deviate significantly from the SMS, with annual certificate of sponsorship allocations and cause assignments being scrapped and being replaced by sponsorship submissions, where sponsors apply to sponsor workers as and when needed. The introduction of Sponsor UK represents a significant shift in the way sponsorship is managed, aiming to streamline operations and enhance user experience, but only time will reveal the full extent of its benefits and any potential challenges which may arise. And lastly, I wanted to remind everyone of the upcoming 31st of December 2024 deadline. For those with BRP cards, biometric residence permits, they must create their UKVI online accounts and register their e-visas. Employers should be reminding all of their staff, and this is not limited to sponsored workers, of this deadline, and provide assistance where they can to avoid any right-to-work breaches. UKVI accounts online can be used to generate right-to-work share codes and to conduct online right-to-work checks. So to summarize, Labour has definitely put an emphasis on homegrown talent and limiting the use of overseas workers where possible. Thank you, and I hope to give you some more updates sometime soon.
Thanks, Rebecca. There are a couple of questions that have come in. I think we'll deal with one now and one at the end. It seems like it's quite specific to their situation. So our business has a skilled worker sponsor license. We're looking to sponsor an employee on a dependent visa, which is expiring soon. But the COS, I think that's the certificate of sponsorship allocation on our license shows that we have 0 remaining. How do we obtain an additional COS?
So if you have no causes remaining in your allocation, you will need to submit a request for an additional cause for this worker. For in-country workers, you have to rely on what's called these undefined causes in this allocation. And if you don't have any remaining because you haven't renewed, then you will need to apply, and processing times are up to 18 weeks currently. There is an expedited service which you can apply for. So what you do is you apply for the additional cause, and then you go through the process of applying to expedite, which can take some time. So you need to make sure that when you're applying for the additional cause, you include all the correct information for the role, you include information on the worker to ensure that the request is successful and you can submit his visa application before his visa expires.
Okay. Yeah, so obviously extremely important that immigration rules are considered in the first instance. We are now about to move on to Donal's section, where unfortunately there is a lot of other consideration for employers in relation to the recently announced employment bill. So if I move your slides on now, Donal, and you're going to chat everyone through that.
Oh, thank you very much, John. And good afternoon, everybody. So today I'm going to cover the key upcoming changes to employment law. I'm conscious we've got limited time available, so it'll be a whistle-stop tour. We've got quite an action-packed array of laws that we're expecting, though, so I'll attempt to cover as much ground as quickly as I can. So without further ado, starting off with the Employment Rights Bill, then we'll move on to the right to disconnect, which I know have both piqued employers' interests, and some other changes outside of the Employment Rights Bill, as well as some of the reviews of employment legislation that we're expecting in the longer term. And I'm going to hopefully round up with some key tips for employers and what you can do to prepare for all of this. Next slide, please, John. So starting off with the Employment Rights Bill. So that was introduced to Parliament on the 10th of October. I think most employers are painfully aware of this, and it contains some 28 changes to employment law, all worker-friendly changes, which are set to come into effect in 2026, with changes to the unfair dismissal legislation not before autumn 2026. Why such a long lead time? Well, it's because the laws have to pass the parliamentary legislative process, and also there needs to be consultation with the relevant stakeholders. Most of these changes, I think we could all see, are fairly complex, so there will need to be consultation, and that will take time. Some of the consultations are open already, others starting off in 2025. So all of that will take time, and then there'll need to be secondary legislation to bring everything into force. One of the key ones, the key changes is new day one rights. Now that's been causing a lot of concern. We're getting a lot of queries around that for employers, but there are essentially two of them. So the first one is unfair dismissal, and it seems to me that this is broken down into two key points. So number one, redundancies. That will be a pure day one right for employees. So employees from day one will have full protection in redundancy situations. So employers will need in those cases to make sure that they've got a genuine redundancy situation and that they follow a fair and transparent consultation process and essentially treat everyone the same way regardless of length of service. For all other reasons, so the kind of classic employment not working out for some reason, dismissals, so conduct, capability, some other substantial reasons, so trust and confidence style cases, there will be a two-tier process. So first, there will be a fair and transparent statutory probationary period to allow employers to assess the suitability of new hires with a lighter touch process available for dismissal. And in all other cases, for employees outside of that statutory probationary period, there will be full unfair dismissal rights, regardless of length of service. The government is currently consulting about what that statutory probationary period will look like and how long it will be. Its preferred length is, we understand, 9 months. But we'll have to wait and see what the outcome of that consultation is to see what this statutory probationary period looks like. But we do know it will have to be fair and transparent. So that would imply things like making sure there are smart objectives and making sure there's a clean probationary framework in place. Flexible working will be strengthened so that it becomes the default position, which essentially means that employers will now have to prove that it's not reasonably practical to allow a flexible working request if they want to reject it. As I understand it, the reasons for rejecting a request don't change, but the burden of proving it's not reasonably practicable will change. So more burdensome on employers and perhaps a bit more worker friendly than it used to be. There'll be a ban on exploitative 0 hours contracts. So I put ban in quote marks because it was expected to be a ban, and that's how it was couched originally. But actually what's happening is not a ban at all, but workers will have the right to a more stable contract based on hours worked over a 12-week reference period. However, they will be able to stick with their 0 hours contracts if they wish to do so. Nothing to prevent that from happening. I'm assuming that there'll be protections against employers exercising loopholes of coercing employees into taking the employer's preferred choice in those situations. But again, we'll have to wait to see how this develops. And there will also be compensation for early terminated and cancelled shifts. Fire and rehire will become much more difficult because the government intends to amend the legislation to make dismissal for refusing to accept changes to terms and conditions automatically unfair, unless the employer can show evidence of financial difficulties and unless they can show the change wasn't reasonably avoidable, and that a fair and transparent consultation process was followed. They're also consulting about lifting the cap on awards for failure to inform and consult collectively. That's currently 13 weeks gross pay per employee, and also introducing something called a right to claim interim relief. So that's something that allows an employee to bring a claim and if an application to a tribunal, and if they're successful, it essentially stops the employer mid-process pending the outcome of litigation. So quite a useful weapon in employees' arsenals if they're trying to stop the employer from steamrolling through negative changes to terms and conditions. Next slide, please, John. The collective consultation threshold will change so that the 20 employee trigger will apply across a whole business rather than just each individual premises. So potentially triggering collective consultation obligations in a lot more situations than is the case currently. Employers with over 250 employees will have to produce equality action plans relating to gender equality, closing pay gaps, and supporting employees through the menopause. So much more of a focus on employers having to take action rather than just reporting the facts as they do now. For example, with gender pay gaps, now having to take action to rectify these issues. The government wants to strengthen the role of trade unions, making it easier for them to get recognition and to enter workplaces to organise and represent workers. There'll be strengthened protection for those undertaking trade union activities. And absolutely, I've got no doubt that there will be the removal of some of the last government's anti-union legislation. So, for example, the requirement to maintain minimum service levels in key sectors during industrial action, and possibly as and yes, so I would expect any of those last government's actions to be reversed in that regard, and possibly the minimum amount of votes necessary, percentage votes, to enable industrial action to take place. I'd imagine that would be reversed as well. There will be a strengthening of the laws around workplace harassment. So we've all seen that the new duty to prevent sexual harassment has come in from the 26th of October. Labour doesn't think this goes far enough and wants to strengthen it by boning up the duty to take reasonable adjustments to a duty much stricter to take all reasonable steps to prevent sexual harassment in the workplace. And it's doing that by explicitly re-including the third-party harassment provisions in the statute. So that's placing it on a statutory level. Query, will that be expanded again to include other protected characteristics? That would seem to me to fit the direction of travel, but we'll have to watch this space to see if further expansion is on the cards, as there's new developments all the time. There will be new bodies set up to monitor and enforce various areas of employment law and also equality. So Labour taking the view that some of the bodies that were set up by the previous government didn't really have as much teeth in terms of enforcement. So I'd expect these to have a lot more teeth in terms of being able to enforce and bring action against employers who are not complying in these areas. The tribunal time limits for bringing claims will increase. We don't know what to. Most of the claims at the moment that you could bring are, with some exceptions, are 3 months minus a day from either termination or the action that you're complaining about. The government plans to give employees a lot more time to bring claims. It's not yet known what those increases will be. They'll be added. It's been explicitly said that they'll be added at a later date. So again, we're watching for developments on that front to see what the new time limits might be. Next slide, please, John. So that's the Employment Rights Bill. So just I thought I'd just cover some of the changes that we're expecting outside of the bill. The first being the right to disconnect, which I know has caused a lot of interest with employers and certainly media interest. The government's currently investigating what this right would look like in practice. And at the moment, we understand that it's looking at the Irish and Belgian models. So I know many employers, we're getting concerned calls about people saying, how can I run a business if I can't contact people out of hours? If those are the models that they end up ultimately following, that won't be the case. It won't be a blanket ban. The focus really is on ensuring that outside hours contacts doesn't become a routine thing. It really is kind of kept back for emergencies. So there will be some flexibility for employers. Nor is it likely to be a standalone legal right. What they're planning to do with it is to make it an ACAS code of practice. But beware the temptation to think just because it's an ACAS code, you don't have to worry about it so much. Yes, you do, because if someone brings a claim and it's found during the course of that claim that this right has been breached, the tribunal would have the power to award a 25% uplift in any compensation. So yes, still absolutely essential to follow the code. But again, consultation's in progress, so we're monitoring developments to see what the outcome of that consultation will be, and what the right will look like in practice. Next slide, please, John. The government is considering merging the two statuses of employee and worker to make one status of worker, which will have all employment rights. Again, we'll be monitoring for developments here, as it's all subject to consultation and further investigation. But if that does go through, then of course all of these new rights that we've been mentioning will apply to that new status of worker, as well as, and not just to employees who currently have the status of having all employment rights. The national minimum wage, I think, as was discussed earlier in the budget, increases to 12.21, which is quite a significant change there across the board. There will be a ban on unpaid internships that are not part of education or a training course. The government's going to be issuing guidelines for employers about menopause and health and well-being. So that will be quite useful for employers to be able to comply with their statutory obligations, I think, but those will be forthcoming. A new equality, race and disability bill will significantly expand the law by making pay gap reporting apply also not just to gender, but also to race and disability. And then also expanding equal pay laws to race and disability too. The government's also looking at how it can enforce paid travel time for multi-site for employees of multi-site employers, where the employee is expected to travel between the employer's sites. Next slide, please, John. Finally, I'm conscious of time, so I'll just run through these longer term reviews, but we know that the government's looking at doing longer term reviews of several areas of employment law, and those are family friendly leave. I have heard that they're a little bit disappointed about the poor uptake of shared parental leave and want to perhaps increase uptake in that area, but there are a number of other areas. So TUPE, health and safety, workplace surveillance technologies. They're looking at introducing a process to bring collective grievances via ACAS. Again, I think as we mentioned, they're looking at merging the two statuses of worker and employee into one status, and also setting up an equal pay enforcement unit. So quite a lot of things, and there's also they're also looking at other things like neurodiversity, long COVID, extreme temperatures, and things like that. So a lot of things for them to review. I can't imagine that following their direction of travel, they won't be looking at it with a view to making worker-friendly changes. And perhaps if the last government made any employer-friendly changes to these things, reversing those perhaps to put to skew them perhaps back in the workers' favour. Next slide, please, John. So, and finally, just thought I'd have a couple of tips I'd leave you with for things that you can do perhaps to prepare. I know I said that there's a long lead time and we're not expecting anything in until 2026, but there are still things that you can usefully do now, I think. First and foremost, I think keep yourself up to date. There's an avalanche of employment law developments happening, so keeping yourself up to date will be fundamentally important. Take advantage of sessions like this and any other things that may be available out there to keep yourself up to date, so that you can react when necessary. Get involved in any open consultations. You can find them all on gov.uk. There's some open right now about employment law that you can get involved in. But if you've got any strong views on any of the areas that you've heard about, absolutely, it's worth feeding into those consultations. You can probably audit your probationary periods. So obviously we don't know what the new probationary period will look like yet, but why not get your house in order with your probationary periods as they stand now and make them as fair and transparent as possible. Make sure that they're consistent, and get in the habit of recording all of your telephone conversations and conversations with employees now. So because that's documentation and record keeping is going to become, it's important now, but it's going to become super important once these new rules come in. But just auditing and making sure everything's as compliant as it can be now, I think cuts your work down when all the big changes really come in. Audit your recruitment and reward processes and packages. Whilst that might not seem relevant, recruiting the right people and rewarding and retaining the right people can in itself reduce the risk of claims significantly. So that's something that I would always recommend employers do. Identify any training needs for managers and decision makers, particularly around if you think there's some weakness in following processes, so grievances, disciplinary procedures, but any particular process, but I guess those will be the big ones. Might be worth sort of arranging training for them now, so that again, that kind of cuts down the work that you have to do when the changes start becoming reality. And also, update your risk register. Have a look at, what these risks will mean for you. If you keep a risk register, update it with all of the potential risks that the new employment laws could bring, and audit your policies, procedures, contracts, and handbooks. See what start planning ahead, thinking about what you might have to change when these new laws come in. Again, and get them as up to date as they can be. Again, I think that just cuts down an awful lot of work and worry when the changes actually start to become real. I think that's it from me from now, John. Do we have any questions?
Thank you very much, Donal. I mean, we have come to the end of our session in terms of time, so thanks very much for all the panelists and all your insights. I think it's an understatement to say I think there's a lot of food for thought there across all of those three areas that we discussed. Thanks for the attendees for bearing with us. I know at the start, particularly at the start of my introduction, there were a few technical difficulties. I think I managed to cover up most of them well, and hopefully you were able to see the slides throughout the presentation as well. For those of you who do want to stay on, we will address some of the questions that were raised. One of which, Donal, was to you in that do all those changes that you just covered in terms of employment law, do they apply to international employees that are posted to the UK for a temporary period or for a longer term project?
Potentially they might do. I think you have to look at these things on a case-by-case basis, but where we get situations like that, what we always advise people is you need to have the contract checked by a local lawyer at the very least, depending on what type of relationship you're using, to make sure they comply with minimum requirements. So yeah, arguably it's very relevant for international employers posting people to the UK to be aware of these things.
Okay, and another question that was raised, and this would be aimed at you, Louise, is how with all the changes to the tax treatment of what was previously considered non-domiciled individuals who work in the UK and moving to the new FIG regime, how are the government going to police that employees and employers are following these new rules?
It's an interesting one, and it's something I quite often get asked about. How's anyone ever going to know anyway? We've heard that HMRC are employing a lot more people. They're recruiting a lot, but we've also seen an increase in employer compliance reviews. So the revenue will ask some questions. International is always a red flag because they always think that it's an area of risk that isn't always dealt with sufficiently well in a company. So one way is that they will just increase these compliance reviews and go from there. Another way that we're seeing checks is the joined up approach of the immigration people and the tax authorities. They're monitoring much more people that are coming and going, and their HMRC are going to companies' house, looking at sets of accounts, identifying there are non-resident directors, for example, and then using that as a reason to go in and say, well, we've looked at your payroll, we've looked at your accounts, you've got a non-resident director, why isn't he on the payroll? So it is becoming increasingly difficult not to hide things, but HMRC are definitely looking at getting information wherever they can. And of course, you've got the exchange of information between countries as well, which is also being stepped up. Where it was something that used to happen occasionally, there is now very much a regime of regularity in countries sharing information. So it's being tightened up, and there always will be things that slip through the net, but I really don't think it's worth chancing it, because, you know, much as Rebecca mentioned about, you know, public naming and shaming, HMRC are also doing that. And going back to Donal's question just now, if I may, about the international employees being affected, the last point on the slide about auditing policies, procedures, contracts and handbooks, that is vital for international as well. So, you know, make sure your HR team have got a policy document, have got a procedures document on how international assignees should be treated.
Okay. And I imagine a lot of businesses will be thinking, well, let's, instead of employing individuals in the UK, maybe we should be engaging with them as independent contractors. But I guess that businesses that are thinking along those lines should be aware, if they're not already, there are, certainly from a tax point of view, there are a lot of onerous rules that need to be considered that could end up you reclassifying those independent contractors as employees for tax at the end of the day. So rules familiarly known as IR35 or employment status rules. And I think Donal, when we sort of look over to the employment law side of things, you've also got to consider status indicators from that perspective as well.
Yeah, that's right. I mean, there's some crossover. Between how tax tribunal, or HMRC rather, and employment tribunals will look at the situation, but just a little bit of a different focus. Tribunals tend to look at, yes, they'll look at the contract and what it says about the relationship in practice, but they'll also look at, for example, so how the relationship works in reality, and that will mostly be done with witness evidence. But yeah, as much as there's a tax issue with the classification, it's also tribunals will look at the same thing as well. And individuals can and do challenge their employment status frequently. I think the Uber case tells us that, where a number of people who were said to be self-employed contractors brought claims claiming to be workers so that they could get national minimum wage and holiday pay rights. And although the contractual documentation made it very clear, they were able to persuade a tribunal after years of litigation that they were actually workers and entitled to all these things. So yeah, it is a key concern. You have to make sure that the contract's in place, and also that the reality matches the contract.
Yeah. Okay. I mean, just one final question, as there are still people still watching, and obviously as a recorded version of this. This one's aimed at you, Rebecca, on the immigration side of things. So this individual, well, this company employs a junior engineer on a graduate visa. His online right to work check says that he has a right to work until April 2025, but his BRP card has an expiry date of the end of December 24. What should they do to confirm his right to work after this BRP card expires, and how can we extend his visa?
So this goes back to my point on registering UK VI online accounts and e-visas. So this employee needs to urgently register his e-visa, and then once he's done that, he can prove his right to work, which he already would have done, but if, you know, for peace of mind, he can do again with his UK VI online account and generate a right to work share code, which he can provide to the employer. And seeing as his visa expires next year, as a graduate, he is eligible to be sponsored as a skilled worker. So if the company doesn't yet have a sponsor license, they should consider applying for one ASAP. processing times for sponsor license applications are up to 2 months. If there are no delays, and preparation can take time. So making sure the license is in place well before his visa expires next year, so that they can proceed with applying for his skilled worker visa is crucial. And just going back to Louise and Donal's points regarding monitoring between HMRC and the Home Office and Employment Tribunal. With this digitization of the immigration system, everything is now being cross-checked, especially between HMRC and the Home Office. It's been mandatory for a while to include PAYE references on certificates of sponsorship, and if you don't include a PAYE reference, you have to have a valid reason. So what the sponsored workers are being paid will be monitored by both the Home Office and HMRC. So just goes back to it's an ever-evolving world towards higher levels of monitoring on all fronts.
Okay, great. So I think we've come to an end there. Thanks again for to Louise, Rebecca, and Donal for their presentations. Thanks for everybody who attended the session. Of course, if you are thinking about hiring workers in the UK or hiring more workers in the UK, perhaps assigning employees to the UK from an overseas office or out of the UK, please do not hesitate to contact any one of us, and we'd be more than happy to pick up any queries that you have. Thanks very much.
Thank you. Bye-bye.